witnesses that we have before us are the result of a bipartisan consensus, and there is nothing partisan about consumer protection. We all want to protect against the abuses and deception and lies that all too often we see in the marketplace. We are completing a year of unimaginable heartbreak and hardship for all Americans. A year of pandemic crisis, healthcare crisis, and consumer crisis. This year of heartbreak for Americans has also been a breakout year for the swindlers and con artists. They have seen it as a bonanza, and in fact, they have made it a bonanza. There have been 460,000 reports of consumer fraud in the past year, according to the FTC, at a cost of more than $411 million, which represents a 45% increase in the numbers of reports, 83% rise in the dollars lost. So these reports show the results of a flooding of online marketplaces with fake personal protective equipment, sophisticated counterfeits, and other kinds of frauds. These sophisticated counterfeits have infiltrated the supply chain, often unchecked by big tech platforms, putting unsuspecting consumers and healthcare workers at risk. Truly, it has become a matter of life and death. As consumers have grown more fearful for their safety, social media platforms have become a mega mall for snake oil peddlers hawking fake cures and prevention. These platforms have been way too slow to respond. They've done too little, too late, and then often only as a result of vigorous prodding, in fact, very strong kicks by consumer advocates and members of Congress, as well as state AGs. Hucksters like Joseph Mercola have spread medical misinformation to millions, denying the science of COVID-19 while reaping profit windfalls, selling expensive vitamins and supplements as cures. One of them he has advertised is this vitamin C liposomol with his name, which he has said will successfully fight COVID, and advise people to take it rather than get the vaccine. To this day, despite FDA warnings, he tells consumers you likely don't need a vaccine. In fact, he creates false fears about the vaccine, and then he offers these supplements, such as vitamin C, as prevention strategies and treatments readily available. They've been shown, he says, to be effective. Of course, he's not only playing fast and loose, he's lying. In protective equipment, we've seen similar kinds of scams. Real and fake protective equipment, which endangers lives. It literally puts lives at risk because the fake 3M devices are no substitute for the real ones. Not only have the social media platforms been enablers, knowing and recklessly enabling these kinds of frauds to occur, but they've also been laggard and lacking in taking action when they had fair notice that many of these frauds were exploiting their platforms. The Federal Trade Commission has been a line of defense, but all too often what we've seen is warnings rather than court action. The time for warnings is over. The FTC must go to court against wrongdoings. It needs to create deterrence through hefty legal penalties and strict court orders, and it needs to refer for criminal action more often and more effectively these kinds of cases. The perpetrators of these frauds don't like to pay money. They don't like to pay penalties. They don't like to pay restitution. But most important, they don't like to be behind bars. And that's what the FTC has to seek. More than baring its teeth, this agency has to use those teeth through the penalties that have been provided, new penalties provided most recently by Congress. So we need to bolster and support the FTC, providing more legal tools and resources where necessary to defend consumers. And as a first step to ensure that the FTC can get consumers' money back when they are scammed, we need to restore 13B authority that was taken away by the Supreme Court when it caved to a shadowy campaign to disarm the FTC. Unless Congress acts, the FTC will have, in effect, both hands tied behind its back. Over the last 4 years, the FTC has secured over $11 billion in refunds for consumers. There is approximately $1.8 billion of American money at stake right now, and I hope that Congress will act promptly and effectively to restore that authority. Let me just say in summary, the path forward seems clear. The FTC must act more swiftly to stop scams, perhaps going to court without Department of Justice authority. It has to seek financial penalties against wrongdoing more vigorously. It has to hold the platforms accountable for aiding scams. And in that regard, we need to re-examine and revise Section 230 to enable victims to go against the platforms as well. And the FTC needs to work with law enforcement to bring criminal penalties as a deterrent. There's a lot of work ahead, and I look forward to tackling it in combination with the ranking member, Senator Blackburn. Again, my thanks for your leadership over the years, Senator, and I turn to you. Excellent description of the explosion that we're seeing in frauds and the vulnerability and lack of enforcement that will result from the 13B decision by the Supreme Court, which could eviscerate large areas of enforcement. And that challenge to us in Congress has been highlighted by Mr. Kaufman and Mr. Kovacic as well. And certainly it ought to be at the top of our priorities as we consider this crisis. And ironically, the increasing hope resulting from the vaccines has only accelerated the frauds that we're seeing. In fact, swindlers have stolen money from senior citizens by promising them at-home vaccinations. There have been pitches to schedule vaccination appointments and checkups, committing identity theft and counterfeit vaccination cards and fake negative results of tests are increasing online. So the challenge is not diminishing with our ability to potentially conquer the pandemic through increased vaccinations. And you mentioned, Ms. Patton, the 350 warning that the FTC has directed to companies to remove deceptive claims. Mr. Kaufman, let's be very blunt. These warnings are just a slap on the wrist. So far, the FTC has brought only one case under the COVID-19 Consumer Protection Act, and I hope that will be a start in increasing vigor by the FTC. I agree totally that we need to increase the resources available to the FTC, as Mr. Kovacic has emphasized. The president's apparently going to seek an $80 billion increase for the IRS. I would suggest something comparable for the FTC in the way of resources. But what plans does the FTC have to use increased penalties and criminal referrals?
Thank you for the question, Senator. We have more cases in the pipeline that will be utilizing the new civil penalty authority that Congress has given us. We think it's a very important tool that we definitely will be utilizing. I also do want to mention that the 350 companies that received warning letters, we're watching them closely to make sure that they don't recur. And if they do, we will also be bringing law enforcement against them as well.
But if those warning letters and the scrutiny are just the cost of doing business, it won't be a deterrent to them. Criminal referrals and increased penalties are what will put them out of business.
And I do agree very much. Increased criminal referrals is something we do. We have a unit at the FTC, the Criminal Liaison Unit, that works with criminal law enforcement throughout the country to get them interested in our cases, and that's something that we can and should do more of.
Let me turn to the social media platforms. We've all seen the fake cures, the fake PPE, now fake vaccination cards. Right now, for these platforms, there's no cost to inaction. They seem to pay attention only when Congress or the state AGs literally kick them in the butt. And often it takes multiple kicks in the butt. Let me ask Ms. Patton and Mr. Kovacic, what changes should we make in the Section 230 immunity that right now these platforms enjoy?
Well, I think that 230 definitely needs some fixing. TINA.org's position is that platforms that profit from the goods and services that they're deceptively marketing should not be able to hide behind that 230 immunity, such that the fix that's needed is that if it deals with commercial speech in which a platform is making money, that they should not be able to use 230 at all.
Professor Kovacic?
Thank you, Mr. Chairman. I don't know if it's simply in the context of Section 230, but I think it's appropriate through perhaps a variety of different legal steps to bring responsibility to bear on intermediaries who are aware or should be aware of the falsity of claims that are being made, to exercise care in denying the use of their platforms to those who make these kinds of claims. I'm not sure if 230 is the only specific vehicle to use. I haven't spent much of my work studying that carefully, but I can think of other legal concepts and principles where we bring responsibility to bear on third parties who know or should know that the conduct taking place through the medium or vehicle that they control is fraudulent, and situating responsibility with the individual or institution that's in a position to control the behavior, that's aware that there's serious harm that can flow from the behavior, I think is entirely appropriate. And I expect that you and your colleagues will be looking at a number of different ways in which this kind of responsibility can be brought to bear on a variety of different actors, including information platforms.
Thanks, Professor Kovacic. Senator Blackburn. We may be having technical difficulties with Senator Lujan. While we're waiting, let me ask a question. I think it's pretty clear from the testimony that we've heard today and everything we know about the FTC that the Supreme Court decision really is an existential threat to the FTC and to consumers. And if we do nothing else in this subcommittee, we need to reauthorize the FTC's authority to protect consumers and put money back in their pockets. That's essentially what 13B enables the FTC to do, put money back into consumers' pockets for their losses. The money that results from penalties goes to the federal government, not to consumers. It's a deterrent, it's a good means of punishment, but consumers see none of it. Let me ask Assistant Attorney General Alexander, because you are doing what I did for 20 years as Attorney General of the state of Connecticut, which is to put money back in consumers' pockets. Could the state attorneys general fill some of the gap left by the Supreme Court's decision in restricting FTC authority to provide restitution if the FTC were to share more of its cases, to refer more of them, and perhaps even for you to seek criminal penalties if the FTC fails to do so?
Thank you for the question, Senator. Yes, I mean, the states do have restitution authority. Our state in Washington, our courts give us very broad, equitable give the courts broad, equitable authority to provide restitution to consumers. But I will say that, you know, without the FTC being able to seek that form of relief, you know, the states sort of become the primary source of restitution. And while we devote considerable effort to consumer protection, the states can't do everything. And, you know, in some cases, the FTC Act is broader than a state's Consumer Protection Act and reaches farther, reaches into professions that some states' Consumer Protections Acts don't cover. And, you know, the presence of a lot of regulators pursuing restitution allows every regulator to focus their efforts on different schemes, you know, and broaden the range of conduct that can be investigated and prosecuted. And you know, the combined efforts of the federal government, the FTC, and the states create a powerful deterrent effect. And when there's one less regulator with the authority to deprive wrongdoers of the fruits of their illegal conduct, that deterrent effect necessarily weakens. I know you asked about criminal prosecution. I'm a civil attorney, and I can't really speak to that specifically, so I'm going to leave that question maybe to my FTC colleagues.
Let me ask you, Ms. Patton, you raised the issue of independent litigating authority. How important could that be to the FTC?
I think it's vitally important to the FTC. When harm is done and consumers need help, time is of the essence. The FTC should not have to ask permission to go in and deal with harmful conduct, and they need to get that money to consumers as quickly as possible. And without independent authority, that cannot happen.
You know, your organization is in the business of educating, and it does extraordinary work in raising warnings to consumers and making sure they know about these scams. Why is education not enough? Education
is not enough because our 320 million consumers in the United States are continually scammed, and they need to be made whole. And education doesn't do that. So without 13B and without a functioning FTC, that's not going to happen.
And part of education is to lead consumers to report wrongs against them, which enable the FTC and state law enforcers to take action to stop the scammers, correct?
That's correct. The Consumer Sentinel network that the FTC relies on all the time is based on consumer complaints.
You know, one may wonder, given all that's been said about 13B authority, who's against restoring it and why?
Criminals?
Criminals, scammers, the payday lenders who exploit working families, the for-profit colleges that prey on veterans, the fake vaccine card perpetrators, or the other kinds of con artists that prey on seniors, and without trying to disparage anyone unfairly, the Chamber of Commerce has said in a letter to the committee, in fact, just before last week's FTC oversight hearing, that it opposes any action on 13B. I recognize that Acting Chair Slaughter and Commissioner Phillips disagreed with the Chamber of Commerce in their testimony, but regrettably, they were provided with that letter just minutes before their testimony. I would be interested to know, Mr. Kaufman, whether you have a further rebuttal to the Chamber of Commerce.
Absolutely. I could spend, unfortunately, far too long with my rebuttal to that letter. I strongly disagree with their propositions. At the outset, they're fundamentally saying that we should not be able to get money from companies unless they engage in egregious fraud. So unless we meet that standard of egregious fraud, we shouldn't be able to get money back from consumers. And I think that is just bad policy. The issue when consumers are deceived is not what was the mens rea, what was the mental state of the company that engaged in the bad conduct. Who should bear that burden? The company that deceived consumers or consumers who relied upon that company and made a deceptive purchase? It is consumers who should get their money back, irrespective of the mental state of the advertiser. So I could not disagree more with so many of the propositions in the Chamber's letter.
And one might ask, what is non-egregious fraud?
The
Garden variety exploitation of seniors or veterans or COVID sufferers?
Absolutely. In the advertising area, that is an area where we think it would be particularly challenging. If there is a bad study that a company is relying on, can you say that it was fraudulent for them to rely upon that study? It creates very challenging litigation issues. I've litigated health claims for about 7 years at the FTC. I've seen firsthand how challenging it is to bring these cases, but then to increase the burden and require some showing of intent on behalf of the company would be unacceptable.
In effect, what the Chamber of Commerce wants to do is convert 13B into a criminal statute.
I haven't thought about it from that perspective, but I agree with your commentary.
Requiring mens rea or criminal intent for there to be a violation, which is unheard of in prior consumer protection jurisprudence. If that were the case, state attorneys general would be straitjacketed in everything they did, and the FTC would be severely undermined. Let me turn to Senator Lujan. I'm told he is available.